Hello and welcome to this NDTV exclusive with the UU Lalit, former Chief Justice of India. He joins us just days after retiring. He had a very short stint as Chief Justice, just 74 days, 2.5 months, but he managed to get quite a lot done. Thank you very much indeed, Justice Lalit, for talking to us.
Thank you.
Very kind of you. Before we get into all of your very brief but memorable legacy in detail, I just wanted to ask you, what was the toughest aspect? Because you've been a judge, of course, you were a lawyer before that, distinguished lawyer, became a judge, Chief Justice of India. What would you say was the single toughest thing about becoming Chief Justice of India?
Various parts. Number one, apart from your judicial work, one has to take care of administrative decisions. And at the level of administrative decisions are multifarious activities. Number one, listing. Number two, mentioning. Number three, bench composition. Number four, constitution benches. Number five, what kind of matters to be listed before constitution benches.
Right.
So for these facets of administrative decisions,
that's one of the toughest.
That was one of the toughest part.
Now, there was always this question of how much someone can get done in 74 days. But you came out all guns blazing. You actually said this, I think, at your farewell. You managed to dispose of 10,000 cases against a filing of about 8,700. Did you already have this in mind when you came in, that you would just turbocharge your innings?
See, weeks before I assumed office, I had called for the details as to how many 5-judge combination matters are pending, how many 3-judge combination matters are pending, and constitution benches of 7 and 9 judges. It was impossible to have 7 and 9 judges in this short tenure of 74 days. Correct?
Right.
So therefore, I did not concentrate on 7 or 9 judges. I concentrated on 5 judges. The day I took over, we were 30 judges.
Right.
Since then, 2 judges have retired and the third one was me. So therefore, today we are 27. So 30 judges, I just divided 5 by 5. So 6 combinations of constitution benches possible. So therefore, I devised the way that there will be 6 benches of 3-judge combination, 6 benches of 2-judge combination. So 18 plus 12, 30. So just pick up 1 combination from 3-judge and 1 combination from 2 and you have a constitution bench.
Right.
Secondly, there were about 55 death reference matters which are still pending. And the death reference matters in Supreme Court must come up before a bench of 3.
Right.
So therefore, if you have just 1 or 2 benches of 3 combinations, the judges get after a while, after about say 3 or 4 death sentence matters, it starts weighing on their mind.
Yeah.
So therefore, one must have combinations getting changed every now and then.
So that also you managed to do?
This also we managed.
Was this tough though, to push something like this through? Because
the system was, the day I took over, oath, same day I had a full court meeting with all the judges, told them what exactly I have in mind. Everybody supported wholeheartedly.
They were all on board?
Absolutely. And that is how we could manage everything.
Okay, this is actually called some called it a T20 approach.
Yes,
to
a certain extent, yes.
To a certain extent, you would say it was T20. But is this, in a way, the biggest challenge before the Supreme Court? That you have both a backlog of cases, but you also have a backlog of appointments, right? There's always a delay in getting judges appointed.
There are a number of reasons. For instance, when I was a judge, and Justice Deepak Mishra was the Chief Justice, our strength had reduced to the level of just 22. So we
against the sanctioned strength of 34,
that time it was 30. After Justice Gogoi became the Chief Justice, it was raised to 34. So as against 30, we were just about 22 judges. Number of reasons. Let us not get into those reasons.
No, why not get into some of those reasons? But
see, at times what happens is that some recommendations are made, perhaps there are certain objections from the government quarter, then they have to have certain deliberations, maybe some inquiries.
Yes.
And so in the process, perhaps I think there is a delay. Yes.
But this is a problem, is it not? Because you know this. Just, in fact, 2 days ago, a Supreme Court bench has asked the centre to explain the delay in clearing of about a dozen names.
That's right.
even though 10 of which was, I mean, you would be aware because this happened during your time, 10 of which was sent back by the Supreme Court, which means that the government has no grounds to sit on it, but yet there's been no response.
See, one can't go into those questions. They may have valid reasons, but the entire process must have a dialogue at various levels. So therefore, after the collegium recommends the names, perhaps I think there must be a dialogue between the governmental agencies and the collegium. And sooner the better. Sooner you actually take care of these issues, the better. Because, for instance, see, today we are 27 as against sanctioned strength of 34. So 7 vacancies, which means 3.5 benches. 3.5 benches would mean that roughly they could take about every bench 60 matters on a Monday, Friday, 120 and 150 matters a week.
That much is getting
so
backlogged.
That is what.
But the implication in the comments made by this bench, Justice Sanjay Kaul and Justice Abhay Oka, was keeping names on hold, I'm quoting from them, is a device to compel person to withdraw names. And needless to say that unless the bench is adorned by competent lawyers, the very concept of rule of law and justice suffers.
That may be, these are some of the comments if you consider one or two isolated incidents. Take for instance the name of a very illustrious name coming from Karnataka, whose name was recommended. And there was absolutely nothing which was heard from the governmental side for a while. The person concerned then lost interest in the matter and then withdrew his consent. So therefore, perhaps I think the bench was referring to cases like that.
Where actually the delay can become a deterrent.
The delay can put off a person and he may say that, sorry, I don't want to be part of this. And it's possible, a given condition, perhaps an individual may take a particular view in the mind.
But this seems to suggest, Justice Lalit, that this is when the judges say it's a device, it's almost seeming to suggest that the government is using the delays to kind of decide who it prefers and who it doesn't.
I may not go to that extent. It is something which the bench has to find. If the bench comes out with a conclusion like this, then yes, certainly yes.
But are you seeing this yourself, that there are talented members of the legal fraternity, lawyers, etc., who are or who may hesitate in coming forward to become a judge because now they're seeing that it can go into this deep freeze?
As I told you, one name from Karnataka is an illustration for before us. So perhaps if somebody thinks on the same lines, one can't say that he is a part of an exception. There could be that thought which may be entertained by others as well.
But in your time as Chief Justice, was there ever, because you talked of the fact that there's a need for a dialogue with the government, with the law ministry, was there any such experience you had of any interface with them?
No, I haven't had any kind of interface so far as that dialogue issue is concerned because I had very little time. 2 recommendations which I made. Number one, Justice Dipankar Datta as the judge of the Supreme Court. That was made around 26th of September, if I mistake not. So just about 4 or 6 weeks. So therefore, that much time you have to give to the government to consider. So therefore, I did not initiate anything because of paucity of time. But perhaps I think my successor will certainly look into that.
All of this is actually becoming very important, Justice Lalit, because as you know, that this is coming at a time when this entire question of judicial appointments is once again being opened up for debate. At the moment, we have what is known as the collegium system, which, as you know, is a group of senior judges who basically appoint other judges to the Supreme Court and the High Courts. Do you believe that this system it may have its weaknesses or frailties, but by and large, do you believe this is this is a good system, that
there are 2 facets. Number one, the legality or validity of that system has been pronounced upon by a bench of 5 judges. So therefore, one has to accept it that this is the norm, which is a well accepted norm, and that's an established norm with which we must go about. Correct. Number 2, actual working of the collegium. There are certain issues in MOP that at what juncture the recommendation made by the collegium, within how much time should it be looked into by the government, within how much time the dialogue must get initiated. There are certain areas which are still in grey shade. Correct. There is nothing like black and white on that issue. But these are matters of convention. These are matters of convention which will get sorted out.
But you believe that the system where essentially judges are appointing other judges should remain as it is?
See, that is something which is the law of the land. So therefore, I don't have any choice in the matter. Whatever is the law of the land, we must actually obey that and follow that and implement it.
Okay, because you've heard what the law minister has been saying. He's been saying a lot of things. He says that this entire system is opaque and not accountable.
That may be his personal view.
And that across the world, judges don't appoint judges. In India, they do.
He is right to a certain extent that ours is a very unique idea where the judges appoint their successors. Perhaps if you see the models of UK, US, Canada, perhaps I think that may not be the situation. But that's exactly the matter where the constitutional amendment came up for consideration before the court.
Right.
And a bench of 5 judges has ruled in that favor.
Right. This is what is called the NJSC or the National Judicial Appointments Commission, where it was the idea was to set up a panel which will have judges, government, independence, and that was struck down.
Once that is the established law, we have to go by that.
But what do you make of, I know you said that it's the individual view of the minister when he said the system is opaque and accountable. But do you think that's fair to call it opaque and, not accountable?
That's for him to decide. So therefore, it is his view. There are certain counter views also coming from various
I'm asking what's your view. Do you think it's an opaque and unaccountable system?
Not at all.
You don't think
so? It's a perfectly valid, correct and balanced way of doing things. Say for instance, the judges from the High Court. They are recommended by a collegium of 1+2 in High Court.
Right.
So those judges are well aware as to who are the advocates who are practicing before them. They are aware on the administrative side as to what is the performance, what kind of profile the lower judiciary personnel have. So therefore they select from these two sources, the advocates as well as the lower judiciary judges. They make the recommendation. The recommendation comes here after screening at various levels. Number one, the state government. In case there are any inputs so far as the profile of that gentleman or the lady is concerned, that input is something which is part of the dossier or the record before us.
Right.
The matter goes before the consultee judges. Whoever is a judge coming from that high court, his views are also solicited. His views are there. Then the views of IB and everything is there. So therefore you have inputs coming from various quarters. It is after that that the collegium at the Supreme Court level looks into the matter.
So you think that this is a good, at the moment you say it's a fair system,
for instance,
it's not an opaque system.
When Justice Ramana was the Chief Justice, at that time the collegium was Justice Ramana, me and Justice Khanwilkar. We perhaps made recommendations and which fructified about 250 recommendations.
Right.
So out of the strength of 750 in the high courts in the country, 1/3 got appointed during that 15 months tenure that the collegium had.
Okay, so you're saying that contrary to some of these suggestions, it is not an opaque system, it's not an unaccountable system. You're saying that there is...
Certainly, yes. So therefore, a system where every viewpoint is considered, has given due weightage, and then the recommendations are made.
But from his side, it seems to suggest that they would want to have a greater say in appointing the judges. The government wants to get involved. But I'm asking you, that could be his view, but I'm asking you, is that a matter of concern? Is there a fear that the greater involvement of a government in appointing the judges will raise the question of judicial independence? Will that be a challenge to judicial independence?
See, as of now, we go by whatever is in place, which is the judgment in NJSC, which has laid down the perimeter of what kind of, the power has to be exercised within what area. So therefore, that's the law for us, and we go strictly by that law.
No, that is the law. But I'm asking you, is there a worry in the mind of someone like you that the greater role of a government may raise questions over judicial independence?
See, these are of course views. Now, for instance, even before all these ideas of collegium got established in our jurisprudence or ethos, we were going by what is called the executive appointees, and all the judges who were appointed in those days were through the executive route. But we have had brilliant judges in the Supreme Court.
Even during that time?
Even during that time. So it is not as if that everything got compromised under that regime. So these are two different thoughts.
Okay.
Of course, the idea is to select the best of the persons, correct? Whichever way one looks at it.
Yes.
I look at it from the perspective, what is the established principle? So therefore, if the collegium is the established norm, we go by that.